All right, so you may recall that last Tuesday we were doing implied causes of action and the Bivens doctrine. Today is Saturday, March 23rd. I'm recording from my office in Charlotte because the recording in Winston at the law school messed up. I'm going to see if this will work. This section of the video, and this video is only about the Bivens doctrine. So what we're doing today is remember that before the retrenchment, Bivens had two possible limitations: the special factors counseling hesitation and explicit congressional delegation. And Bivens didn't tell us much about either factor. And after Davis v. Passman and Carlson v. Green, those cases tell us that these two possible limitations really are not limitations at all. They're not very high hurdles. Now, the notes on pages 5 through 7, which are pages 771 through 775, have a number of cases that refuse to extend the implied damages cause of action in other contexts. It's what I call the retrenchment. For the most part, they use the special factors limitation to thwart the implied cause of action. If you look in the Chappell case and Stanley, that's the military context, and the availability of administrative remedies in Bush and Chalicki. In 1994, in the FDIC versus Meyer case, that's on page 774 of the text, the court held that a federal agency cannot be sued under Bivens. Only individuals can. And that was despite the fact that there was a pretty broad waiver of sovereign immunity that attaches to the FDIC. But these cases, these retrenchment cases in the notes on 771 through 775, do not necessarily cast down on the viability of Bivens. It just says that they're not going to be extended beyond liability of an officer for constitutional violations outside the military context where no other reasonable remedy has been provided by Congress. On page 774, you find the Congressional Services versus Malesko case, which makes an important change here. In Malesko, the court set up a pretty high realistic bar, which was they introduced the idea that state remedies might be a bar to a Bivens action. Now, that's an interesting development since in Bivens, as we discussed last Tuesday, you had the potential state law actions of false imprisonment and trespass under New York law. And the court there said in Bivens that those did not address constitutional violations, that state law defenses to that and state law causes of action might not even touch the constitutional questions. In Malesko, a federal prisoner suffered a heart attack after being forced to climb a set of stairs, and the issue was whether he could bring a Bivens suit against the corporation that ran the federal prison. So part of that Malesko decision goes back to FDIC v. Meyer, where the court said Bivens is about suits against individuals, not about corporations. But the key for Malesko on 774 is that it relied on this idea that state remedy was available and would foreclose Bivens. As to that latter part, we'll talk about that in a few minutes when we talk about Minichi. But first, I want to talk about two other Supreme Court cases in this line. The first is Ashcroft versus Iqbal, which is noted on page 7074. That's a 2009 case coming out of the 9/11 attacks. And most of us know Iqbal as a 12b6 pleading case. That case always gets decided when you're arguing 12b6 motions and you're claiming that the pleading is too vague, too insubstantial to survive a motion to dismiss. But it does have something to do with this Bivens doctrine. Iqbal was arrested and detained after 9/11. One of the things you will know about 9/11 cases is that they are always going to be different. They are unique in the history of this case, or unique in the history of this country, or at least in the modern era. So Iqbal sues the Attorney General, claiming that the terms and conditions of his detention violated his constitutional rights, in part because it was based on his religion and thus violated the First Amendment, and because it was on account of his national origin and therefore violated the 14th Amendment equal protection. The Supreme Court dismissed the case, but importantly, what the court there said was that you had to have a very high pleading standard with regard to the Attorney General's involvement, and before they're going to bring him in under something that looks like respondeat superior and make him liable for the wrongs of committed by lower level officials. But the court did say, and this is the important part why I'm discussing Iqbal in the connection with Bivens, the court says in 2009 that implied causes of action are disfavored and that the court is reluctant to extend Bivens, and that they had already looked at this First Amendment question in Bush, and if the government had actually made a Bivens argument here, the court would have agreed with the government and said you can't bring this case against Ashcroft. And also the court, as I indicated earlier, said you can't really bring a respondeat superior case under Bivens. So remember I said when we were talking about Bivens that you have to look at Bivens both in 1971 when it was decided, when the Borak versus Case decision held sway, and the court was saying we can find implied statutory causes of actions anytime it is necessary or positive to fulfill congressional policy issues. Now in 2009, the court, in the same kind of retrenchment on the statutory side, is doing it on the constitutional side and saying we're not going to extend Bivens. It's a decision of its time that we're not going to look at extending in the future. So the next case that we want to talk about is Wilkie v. Robbins, and working our way into Minichi. In Wilkie v. Robbins, that was a great case because the government screwed up. They had gotten an easement from a property owner but failed to record it. Then the property owner sells the land to Robbins, who obviously is not bound by any easement that's unrecorded. So the government comes to him and says, let us record this easement on your property. And Robbins says, well, if you want to pay me some money, we can talk about it, but not just because you screwed up earlier. So he refused to give that easement without getting some payment, and the government embarked on this low-level, what I call a Donald Segretti Watergate-era campaign of dirty tricks. They harassed him for years. They made unsubstantiated criminal cases against him. They trespassed on his land, imposed petty administrative sanctions against him. And ultimately, Robbins gets tired of this, and he sues on the basis of Fourth and Fifth Amendment violations. The distinctive opinion about Wilkie is this. Justice Souter wrote the opinion, and typically when you get Justice Souter, you get a new test. And in this case, we get a new test, and that's the Wilkins v. Robbins restatement. And Justice Souter said that in looking at whether to adopt a new Bivens implied cause of action for a constitutional violation, the Supreme Court is going to ask two questions, and a lower court has to follow it, obviously. First, you ask whether there are other adequate remedies. In Wilkie, the court said the remedies available to Robbins were not adequate because his complaint is about the pattern of harassment. And being able to respond to each and every little petty thing is not sufficient. Essentially, what Wilkie's saying is, here's a pattern, it's just too much. The second question is where Robbins loses here. Even if there are no adequate remedies, and remember in this case, Justice Souter is saying, we agree there are no adequate remedies, is there still some good policy reason not to recognize the implied cause of action? So you could put a question mark at the end of number 2 there. Here, this latter factor, number 2, is decisive for two reasons. First, Robinson's claims were not that all of the actions against him were badly motivated, just that it was too much. And Justice Souter for the Supreme Court said, how do we figure that out? What I might think is too much is not what you might think is too much. And so there's no judicially manageable standard there. That harkens back to the non-justiciability political question doctrine that we talked about in the Nixon versus U.S. case some weeks ago. So the difficulty of coming up with a judicially manageable standard here counts against implying a remedy. And secondly, if the court allowed this kind of case, when somebody thinks that government officials have sued and have gone too far in pursuing a legitimate aim, we will invite an avalanche of lawsuits. So no judicially manageable standards. Number two, an avalanche of cases that we can't manage. Those are really good reasons, Justice Souter said, not to recognize the implied cause of action. As we have seen in other areas of federal courts, this is a statement about the workload management of the federal court system. If we don't have a good standard to deal with these cases, that's a really good reason of not increasing our workload. So this is the framework that gets us to Minichi in 2012. That's the next to the last major Supreme Court decision on it. And in the Minichi case, the Supreme Court decides that there is no Bivens action against employees of a private prison contractor. And there, the court held that state tort law can compensate or deter constitutional violations through the compensation remedy. The problem is, just as in Malesko, the court puts the focus on deterrence. But you will remember in Harlan's concurrence in Bivens, he said that a constitutional remedy, should be available even if it doesn't deter violations, because he talks about vindication to some extent of the constitutional rights. But in the Minichi case, the court makes a very strong link between deterrence and the state tort remedy. Liability should, the notion of paying damages, all other things being equal, deter the conduct that gives rise to the liability. So we could argue that standing alone, compensation isn't going to do it. It's this notion of vindication of constitutional rights. So that brings us to the last case, which is the Ziegler versus Abbasi case in 2017. Now that's interesting for several reasons. First, it's a 4-2 decision because Justice Gorsuch had just been appointed to the court. He was not there when oral argument was heard, and therefore he did not participate in the case. And Justices Kagan and Sotomayor were part of the Obama administration during this policy time, and therefore they recused themselves. But even though it's a 4-2 decision, it's still a binding Supreme Court decision. So this was a case brought by post-9/11 detainees. So you know already that it is a unique situation. The policy at issue was the hold until cleared policy of the Obama administration. So the plaintiffs there are challenging the terms and conditions of their confinement, just almost like the Iqbal case. And they sued 3 Department of Justice officials and 2 wardens. And the court there, in a 4-2 decision, with Justice Kennedy writing the decision for the 4-justice majority, held that no Bivens action. And here's what the court said. First, Bivens is a product of its time. Remember, Bivens was decided in 1971 when you had the Borak versus J.I. Case decision. And the Supreme Court saying we're not going to overrule Bivens, but we're not going to extend it. So the best strategery is to put Bivens in its own lockbox. For those of you who are in the live first attempt to make up this class, I told you that you got bonus points if you could figure out where I got strategery and lockbox from. So as not to bore you anymore, I'll tell you. It comes from a Saturday Night Live skit, Cold Open, in 2000 in the debate between Al Gore and George W. Bush. Go watch it. It's pretty funny. So the court's saying we're just going to assign Bivens to the historical heap. Bivens actions can be brought on under the cases where Bivens existed, but we're not going to extend it anymore. Justice Kennedy said the new question to ask is whether the judiciary is well suited, even when there's no congressional action or instruction, to consider and weigh the cost and benefits of allowing a damages action to proceed. So remember, Bivens had as a limiting factor this congressional delegation issues. So the notion would be if Congress had said, here's a path to a remedy, the court's not going to imply a cause of action under the Constitution. Here the question's being changed. It's saying even if there's no congressional delegation, are we the right ones to do this? Congress had not prescribed remedies for post 9/11 detention policies, even though the United States Patriot Act required the Department of Justice to make periodic reports to Congress on abuses in the fight on terrorism. And the court finally said in the Ziegler case, or implied at least, that congressional silence has meaning in the sense that if Congress did not want private rights of action, that's what its silence is telling us. Because, to put it in a better, more straightforward way, had Congress wanted a private right of action for violations in the detention policies that were adopted by the executive, Congress could have passed a statute to do so. And not on the slide, but the court also made the point that this was a policy decided at the very highest levels of government in response to a major terrorist action. And it's that last part that controls this case. The 9/11 cases, we'll see some of that in the habeas corpus area as well. They are just going to be special. And it's almost like normal rules don't apply. So that is our wrap up of what in the syllabus is class or unit 14, the Bivens implied cause of action for a constitutional violation. So Bivens is now relegated somewhat to history. It's going to be very hard for a plaintiff nowadays with a conservative Supreme Court to find a new implied cause of action under the Constitution. Next time we will be starting our discussion of sovereign immunity. I plan to do that in another recording in a little bit. Thanks. Have a great day.